120, 125 people and growing here in attendance. Last time Michael spoke, within about 4 days of the time he spoke, he emailed me and he says, oh my gosh, lots of stuff that I talked about has changed. So we're trying to recap here, just because this is a moving target, and make sure that you have the most up-to-date information. I'd like to send a huge thank you here to Michael, he's here with us in our office today. Michael and his law practice specialize in supporting and defending employers in employment litigation since 1994. Today, Mike will be discussing the changes and really an update as it relates to employment and COVID-19. As you know, this has come upon us rapidly, and there's changes coming on a pretty regular basis. Michael's contact information will be included in the slides, and afterwards we will also send everybody a link to the recording. We have 60 minutes on the schedule for this. We will have a hard stop at 11 a.m. Would you mind please sending some "I can hear you" replies through the chat, so we know that the audio is clear here. Sometimes we don't know because of the nature of this. All the attendees will be muted during the presentation so we can get through the information, and we will be trying to answer as many questions as we can. What do you think for time, Michael? 30 minutes to go through the information? Yeah,
and we also have, Manning has collected questions already from people, so we'll be interspersing those in through the talk.
Okay.
A number of the questions concern actually compensation still, so we need to make sure I get to that. There's much more material that I can cover. A lot of this is somewhat a reiteration of what we discussed before for those who were here previously. For those who weren't, we'll also go through that pretty quickly, but want to make sure we go over the basics and then go from there.
So since the last presentation and prior to this one, we've had a number of questions that have come in to Manning. She's put those together for Michael. We'll do our best to answer those. If you have additional questions, which I'm sure you will, please submit them through the chat feature. We will record them and do our best to answer them. So I'm going to turn this over to Michael, say thank you very much for being with us today.
Certainly.
And the ball is in your court.
Thanks for the opportunity to talk to everyone this morning. I hope everyone's healthy, well, and you and your family are doing well through these times. We're going to go through this quickly in terms of what we're going to cover. We're going to focus on the new federal and state measures enacted in response. This is what we did before, current laws and their application and other issues. The main highlights of today will, of course, be the regulations that have come out and how those regulations have changed. There were a number of questions that people asked during while we were all waiting for the regulations to come out. The regulations answered some of them, and so we will address those today. The first, we're going to cover the two big leaves. That's what we're going to cover today. The first one is the paid job protected leave under the Family Medical Leave Act. Just start with who is covered under this. This is an expansion of the FMLA. So the FMLA, which for years, since 1993, has covered those with 50 or more employees, it has now been expanded out for this leave to cover those with 499 and less employees. I've been getting a lot of questions in terms of, does that mean we're covered under the entire FMLA now if we have under 50 employees? No, still just covered under this section of the FMLA. It does not open all the FMLA to small employers. So as we say here, this is different than how the FMLA has read for 27 years or some period of time. 17 years, my math. So 27. My math is bad this morning. What does it provide employees? They have the right to take up to 12 weeks of job protected leave. It provides employees, as we'll talk about, 12 weeks of paid leave under the FMLA for certain conditions. The key questions that came out in particular concern who is not covered under the Act. Well, let's start with the basics. Everyone 500 and above are not covered under the Act. Additionally, healthcare providers, this was identified in the law, what we talked about before. Healthcare providers are not covered under the Act. Emergency responders, they can elect to exclude employees from this Act as well. In the law provided the Secretary of Labor the authority to issue regulations to define what it meant by certain healthcare providers, emergency providers, and specifically for those of us with under 50 employees, it said that the regulations would address how those organizations with under 50 employees could claim that they could not provide the leave because it would jeopardize the viability of the business. So let's go over those two issues here. Healthcare provider in the FMLA is defined and has been defined since its enactment in 1993, but it was defined, as the regulations point out, to address who an employee would need to get certification from should an employee, request FMLA leave. It was identified as healthcare provider. So when the department came out with these regulations on who healthcare provider, they made it clear that they were not going to limit themselves to just that definition of healthcare provider. It was going to be much more expansive, and I have that identified here. You can see it's any doctor's office, healthcare center, post-secondary education, nursing facility, nursing home, any facility that performs laboratory or medical testing, pharmacy, or any similar institution. Definition also includes those who produce medical products. A very broad definition of healthcare provider. So if you are over 500 employees or you are a healthcare provider as this is defined, you are specifically exempted from this. You do not have to comply with either of the two leaves we're going to be talking about. Additionally, it identifies emergency responder as anyone necessary to transport, healthcare, comfort, nutrition, those issues, includes military or National Guard. Those are the healthcare providers and the emergency responders. So one of the questions that came up when the law first came out, that we were waiting for the regulations, was what were those definitions? It is a very broad definition of healthcare provider, flipping back to there. Excuse me. So if you are providing medical services, make sure you're taking a look at whether or not that is required under, or you're required to comply with it. The small business exemption is was one of the ones in particular we were waiting to see with the regulations, because it allowed businesses with under 50 employees to say, I can't do this, I can't provide this leave because it's going to jeopardize my business. And the regulations have addressed three ways where an organization needs to, in essence, establish that it would jeopardize their business. What I've been advising organizations with under 50 employees who are looking to perhaps claim that it jeopardizes their business, I've been recommending that organizations actually prepare a document that addresses this issue in terms of a background statement along the lines of what the leaves are, a statement then following that with respect to it also provides an exemption, and then something that you could do is just simply identify the three criteria. You only need one, and then check boxes next to the ones that are applicable to your organization. It does not have to be filed with the Department of Labor. It does not have to be provided to employees, but it is something I recommend employers do, simply because that way they have it in place before requests are coming in. Once requests are coming in, it may look like we're just doing it in response to the request as opposed to jeopardizing the business. So encouraging organizations to use this as a written document. What are those three issues, those three exemptions? The leave would cause the employer's expenses and financial obligations to exceed available business revenue and require the employer to cease operating in a minimal capacity. This would be something, excuse me, for those of you who are, I know there was a talk earlier this week, are looking to the program, the PPP program, the payroll protection program, that would, if you are part of that, if you are receiving funds under that, or as part of that, you would need to consider that as part of this. So before you say, well, our financial obligations exceed our revenue, keep in mind that if you are receiving funds under the PPP, that may be inconsistent with claiming we also can't provide this leave under the sick leave. If this continues beyond the PPP and those funds then stop coming in, that may be something down the road that you can consider, but initially make sure you're looking at that with respect to the PPP. The second exemption is the absence of the employee who requested the leave would pose a substantial risk to the financial operation capacity because of the employee's specialized skill and knowledge of business or responsibility. If you have an employee who is so critical to your business, this is an exemption to a requirement for small organizations to provide this leave to their employees. That may be more on a case-by-case basis than certainly this one, than the financial obligation issue, but if you have those employees who are requesting, you can deny if you receive a request from someone who would jeopardize the business. And then finally, the employer cannot find enough workers who are able, willing, and qualified and will be available at the time and place needed. So if you have requirements to have 10 workers and you only have 12 and 4 or 5 come in saying we need this leave, that would be another exemption. So identifying those 3 exemptions on a written document, identifying then which of those an organization is going to use to exempt themselves from them. Does not need to be filed with the DOL again, does not need to be provided to employees. Obviously, the last 2, if an employee requests leave under these, that would be something that you'd want to identify for the employee as to the reasons why you're denying that leave. But those are the small business exemption. It's only applicable for those with 49 or less employees, not applicable for those with 50 or more. How does the leave work in general? Well, a covered employee may take up, as it said, may take up to 12 weeks of paid leave. It's job protected, so their job remains unless it goes away. Because the employee must care for the child and if the child's school or place has closed, which of course most of those in Colorado have closed. The first 10 days of the leave are unpaid, but it can be paid under the 14-day sick leave, which we will be discussing next. But so in essence, it's 12 weeks of leave, first 2 weeks unpaid, next 10 weeks are paid. Now, the rate is paid at 2/3. The employee's rate up to $200 a day, capped at $10,000 total. Organizations can't require an employee to substitute paid leave, PTO, vacation, CAL, whatever you may call it. You can't say to the employee, you have to use paid leave, your paid accrued leave instead of this leave. You have to allow the employee to use this leave, but you can permit or require the employee to use paid PTO leave, paid leave, to cover that 1/3 that is not covered in the this federal leave. So the 2/3 would be paid under this leave, and then you could take 1/3 out per day to cover the remaining employees' leave. That way, they're paid in full.
Wonderful. I have a couple of clarifying questions. Beth asked, she thought the age was 15, not 18.
I've only seen 18, Beth. That's a good question. I will double check that. I have not seen 15. I thought it was 18, but I will double check on that.
Okay. And then Virginia has asked 10 business days or 10 calendar days.
In terms of the leave?
Yes.
I think the better way they discuss it in terms of business days. I think the better way to look at it is, my pen just ran out. I think the better way to look at it is the issue of 80 hours, because this leave is subject to intermittent leave. If the employer and the employee agree that the employee can take that leave instead of in a lump sum, the employee maybe, let's say, only needs to care for the child for 4 hours a day, then that leave would be for the first 4 hours, and then they may be able to work the next 4 hours. So I would look at it more as an 80 hours than I would necessarily look at it as number of days or number of work weeks.
Wonderful. And then Sheila asked, is it 12 weeks for the emergency FMLA in addition to 12 weeks of regular FMLA?
You know, that's a great question. I don't think that was made particularly clear under the regulations. Of course, the FMLA is still out there. If an employee is taking leave, that's unpaid leave. They did not convert that to paid leave. They didn't talk about in the regulations, so I would still look at that. That's an interesting question.
Thank you.
Good question. Those who are on a part-time schedule, you're supposed to look at it for the what was their schedule for the 6 months prior, and then give them a prorated share of that. If they haven't been working 6 months prior, as the regulations kind of show, it's as needed, or as kind of thumbnail it. Was the employee working 5 hours a week, 6 hours a week, 6 hours a day, and base the pro rata share based on that. As soon as practical, employees must provide notice of the leave to the employer, to the employees. The department has put up the poster on its website, so those who have not had the opportunity yet, make sure you go on the DOL's website. That poster is available, can be sent out to employees, can be sent out to employees, either email, just letting them know.
Hey, Michael.
Yeah.
Something on this. So we have that poster.
Okay.
And after the webinar is over, I'll have Manon email that out to all attendees.
Great.
Whether you're our clients or not. We've already mailed it out to all of our clients, but that seems like kind of a everybody needs one kind of a thing, that we have it. It's certainly easy to do that.
Yeah, great.
Yep.
Great. What we've talked about before is that this is coming back as a credit, and that's against their future Social Security payments, those issues. Finally, those employees need to be returned to their previous position. The key under this is, the key that came out in the regulations is the definition of healthcare provider and what small employers need to do are the two big things.
Michael's multitasking here
Yeah.
for a second, so
Well, I'm multitasking because I'm texting back to my office that question about is it 15 or 18. I want to make sure I didn't miss that.
we have teams.
We have groups across the country, because Emily's in Florida addressing this as we talk. The 14 days, this is the other leave. So we have the 12 weeks, and then we now have the 14 days. We'll go through this quick. The big issue that came up under this is the definition of quarantine. Still continues to be one of the basis for leave under this, and so we'll address that in a second. Until December 31st, same thing as the last one, employees of employers with less than 500 employees and government employers are entitled to 80 hours of sick leave. Government workers and union are also eligible for the leave. Part-time covered, they're covered to the same extent they were before. You look at their pro-rata share of the number of hours they're working. There is no minimum number of days for this leave, so an employee who started on March 31st or who started sometime in March, they would be eligible for these 80 hours.
So Michael, just to be clear on this, if you have a part-time person who averages 40 hours every 2 weeks, they'd be eligible for
40 hours.
40 hours, right?
Yep.
So it's directly related to their average work hours over 2 weeks.
Right, exactly.
Okay.
We're getting a lot of questions about pregnant employees who have been ordered by a doctor to stay home. Is that considered quarantined?
We'll get to, great question, we're gonna get to when we go through our 6 bases. That's a really good question. Let's go who's not covered. Again, not covered, you're more than 500. Employees of healthcare provider, it's the same definition as under the FMLA, the expanded FMLA, so that's still there. If you have a small business, 49 or under, those same exceptions apply, jeopardizing the viability.
We have some more questions about defining a medical provider. Is somebody who provides laundry service to a medical facility?
That's an interesting question, both under the quarantine and the quarantine order from the governor, and which we'll get to in a second, and the healthcare provider. If you look back at the healthcare provider, if you look back at the healthcare provider definition, go here. Nursing homes, healthcare provider, any facility that performs laboratory medical testing or any similar institution. It does not seem to cover anyone who provides services for the healthcare provider. Now, where that will be interesting is under the governor's order, which we'll talk to in a second. It's very expansive in terms of any organization that provides support for a healthcare provider is exempted from the governor's order. So it gets into the question of whether or not, for example, a laundry care facility, a legal office, an accounting office that provides support to a healthcare provider is exempted under the governor's order. That will be a critical issue, as we'll go through in about 2 seconds.
Only if you want clean sheets in the hospital.
That's pretty much true. Which we all do. Yes, Emily just confirmed that it is 18 on the child care, so that appears to be the same. Let's go over the key issues under the order, which is here. There are 6 bases for, we say 5, but really what they did in the regulations is they split 1 into 2, so they made it 6, but these are the same. The employee is subject to a federal, state, local quarantine order told by a healthcare provider that he or she should self-quarantine due to COVID-19. So if you have a pregnant employee, for example, who is told by their healthcare provider, you must self-quarantine due to COVID-19, that would be covered under this. The employee would be then eligible for this leave. Now, if an employee just simply said, because of my pregnancy or because of whatever reason, I'm going to self-quarantine, that under this exception would not apply. Because this one goes to just the healthcare provider that they should self-quarantine.
So, Michael, let me ask you a question. So, on the self-quarantine piece, for this particular instance, because we've had a number of questions about pregnancy, pregnancy obviously lasts longer than 2 weeks unless you're right at the end of term. So how would that work out after the 2 weeks was over for an employer of 15 to 25 employees?
You would, at that point, need to potentially look at other leaves. Do you have PTO available? Can you make an accommodation because the ADA has been expanded out to include pregnancy? Those would be considerations smaller organizations need to make. Obviously, if you're 50 or more, you have obligations for pregnant employees under the current or the previous and still existing FMLA, but smaller organizations would not need to be covered, would not need to address those leaves.
So they wouldn't, this new FMLA coverage at 2/3 the paid, this piece at 2/3 of wages, that wouldn't kick in this case?
That would not, the initial leave for the child, that's really for a child who can't attend school.
Okay.
Presumably.
I thought that'd be a good clarification.
I guess you could claim that in the first couple of weeks, I was going to seek daycare for my child, and daycare is no longer available. I have to admit, I don't never had children, don't know how quickly one goes to daycare.
Not with a newborn, not that
Yeah,
quick.
you wouldn't think.
No.
But perhaps that would be something to
Okay.
look at, because that is daycare as well. The key issue that we get a lot of the questions on is that first phrase, the employee is subject to a federal, state, or local quarantine. The question keeps getting raised, or kept getting raised until this came out. What exactly does quarantine mean? It is very broad under the regulations. Basically, quarantine order includes any order that advises some or all citizens to shelter in place, stay at home, or otherwise restrict their mobility. That is much broader than the initial law. It is somewhat consistent with the poster that came out before the regulations, so we somewhat saw this coming, that it was going to be very broad. But here's the flip on this, which is we do have the Colorado stay-at-home order qualifies as a quarantine order for purposes of these two leaves, no question about that. But if an employer is a critical business, as set forth in that public health order, its employees are not subject to a quarantine order. So if your business is deemed essential, and if your employees are still able to come to work, they would not be covered by this stay-at-home order. So for example, I'll take law firms because the governor's stay-at-home order was amended the day after the order came out to include law firms as a critical business. Our employees are now exempted from that order, so unless one of our employees met one of the other 4 in this slide, but it's really 5, unless they met one of those other 4 or 5 requirements, they would not be eligible for the sick leave because they are not under a quarantine order. That's where we get very broad in terms of support services for healthcare provider. If your organization is under that, there would be an argument that you would not need to comply or provide this leave. Yes?
We have an interesting question from Rachel. She says, as a surgeon's office, we can choose to exempt ourselves or not. Is that correct?
That's correct.
And we do not have to exempt our employees?
That's correct.
Thank you.
That's an interesting question from Rachel, because then it would seem in those situations that those organizations would be eligible for the 2/3 credit. If, on the other hand, you are not covered, you're under over 500, but you choose to give this leave, I'm not sure the credit's available for you because you've been exempted from this leave. Something I wish the regulations had addressed in a little more detail, but they did not. So the paid sick leave can only be used by an employee subject to the quarantine order for in essence, non-essential businesses, if the order prevents an employee who would have been able to perform work at the work site or telework from home. So for example, I think Telluride is under basically a lockdown order at this point. They can't leave. At that, those employees would be eligible for that leave, because even if you work for an essential organization in Telluride, you're basically locked down. They would be eligible for this leave, but similar organizations, for example, in Grand Junction, who are not under a lockdown order, would not be eligible. The employee has to either not be able to perform work at the work site or able to perform work at home. So if they can do either, if they can telework from home, they're not eligible for this leave. If they are able to get to the work site, they're not eligible for leave. So make sure you're looking at that governor's order with respect to it.
But if they were sick, they would qualify.
If they were sick under the final one, which is the 6th one in the
Right.
regulations,
So
if they were experiencing COVID-like symptoms,
even though they were an essential business, they would still
even though they were essential business, they would still qualify. So what you have to really do is keep track of as I said, 5 or 6, depending on how you have them listed out. I think in the materials I have them listed out as 5, but that's because in the regulations, the first one was split into 2.
Right. Like in our example as a company, we have about 1/3 of our workforce working from home.
Mm-hmm.
All of them could work from home.
Mm-hmm.
And thank goodness we haven't anybody sick yet, but if somebody actually did get sick, they would qualify for this leave.
They could qualify for the leave. Then the question becomes, can they perform work from home?
If they were sick.
If they were sick.
Right.
Could they telework from home? Are they able still to answer phone calls?
Right.
Are they able to still do those kind of things? If they have very limited symptoms, they may be able to continue working.
Okay.
So maybe they're not eligible. It would be they're not able to work because of the symptoms prevent them from working in the sick category.
Lots of gray area.
Lots of gray area. What you want to do when you have an employee requesting leave under the 80 hours is basically walk through each of these five. Five we have listed, as I said, 6 in the regulations. Is there a quarantine order? Well, if you're an essential business, no. Then, is the employee, is the employee experiencing symptoms of COVID and seeking medical diagnosis? Under that leave, it's 511 per day, 5,100. Are they caring for an individual? That's not just a family member, that is an individual who must self-quarantine, then it's paid at 2/3. And then, this is the child care leave, and are they experiencing their symptoms? You have to walk through each of those 5 each time an employee asks for leave to see, are they able to work but for these issues?
Okay.
If they are able to work, then they would not be eligible for this leave.
So Tracy asks, they have an auto sales, or they're in auto sales, and are able to sell remotely, and an employee chooses not to sell from home. That doesn't make them eligible.
Yeah, that would not make them eligible. If they're able to sell from home, if the employee is not experiencing symptoms that's preventing them, if the employee is not caring for a child, if the employee is not caring for an individual who must self-quarantine, or they're experiencing symptoms of COVID-19 and waiting, if they're just simply making that choice and the employee could work, that leave would not be eligible, they would not be eligible for that leave. Talked about this, part-time employees are eligible for their prorated share. So based upon the above 5 scenarios, because we have it listed as 5, employees that do not have the coronavirus to get paid sick leave. In other words, not all employees will be able to provide a doctor's note, but they may be still eligible if any of those 5 scenarios apply. As I talked about, FMLA applies to the employee's spouse, the employee's child, or the employee's parent. This, with respect to at least 2 of those criteria, are referenced individual, not simply family members. They cannot find a replacement for those kind of issues. Employers must provide notice of their rights. As we've talked about, this would normally be in a break room. John's going to send out the poster. Think about maybe emailing it out those issues. I want to get through this stuff. Questions on? No. Okay. The federal unemployment contribution, this is just a quick slide. This is a portion of the act designed to reduce benefits or reduce barriers for unemployment benefits. Basically, within 60 days after March 18th, there's going to be an influx of money. It's my understanding that the governor is going to sign that requirement, has not done so as of yesterday. We're still waiting for the governor to sign that, so our citizens in Colorado will be eligible to receive that. I want to get to, let me go back, because there's a lot of questions that we were asked. Let's see, if I understood correctly what I read in the regulations, we can ask people to stay at home because of not having to work due to slowdowns, and we are not required to pay them. So, and this is in a couple of other questions with respect to salary. Yes, if you want, I can skip forward to where that is. If you want, you can, here we go. You are only required to pay your non-exempt employees for those hours that they actually work, or that they're under one of the paid leaves, or perhaps they're using your paid leave. So if you have an employee who's non-exempt, it's an hourly employee, that employee, if they are sent home, is not entitled to receive any pay because they're not working. If, on the other hand, they go home and they're able to perform a little work, then that employee would be eligible to receive pay for that time, but would not be eligible to receive pay for otherwise. The trick then becomes, well, what to do with exempt salaried employees, those employees who are paid a salary over $6.84 per work week and are working any part of the day or any part of the work week. Don't forget that when your exempt employee, because someone asked a question, does a salaried employee receive their full salary for the week even if they only work one day of the week? Yes, they do. They would be eligible for their entire salary unless the reason for the employee not working the rest of that week, and in this person's question, that was one day. If, for example, the rest of the week they were taking personal leave or they were taking their own sick leave, there would be an argument that you could deduct from their pay. But if we're sending salaried employees home and they're not, and they don't perform any work the rest of the work week, they would be entitled to their full salary. So make sure we're not deducting from salary for a partial work week, or if an employee is working a partial day, and then is, like I had someone say to me, well, the employee is going to work on Wednesday, but they're only going to work half a day because then they're going to go out and golf, was the example, the half day on Wednesday. That would make the employee eligible for the entire work week of pay because they worked half a day on a Wednesday, they didn't take off any time, and then the employer was thereafter closed, didn't require the employee to work. So exempt employees get their salary for any work week in which they perform work, no deductions from that, and that's what we say here, performs no work. Deductions can only be made for full days that exempt does not work due to personal reasons or sickness, but not the employer closing. So if you only do half days, the employee gets paid their full salary. Yes?
So Nina is asking, is it okay if they convert their exempt employees to hour prior to reducing hours?
Yes, you can always reduce, everyone at their basic level is non-exempt. So we can always move employees from an exempt status to a non-exempt status. How do we do that? Generally, how we do that is we convert a salaried exempt employee to a hourly employee. When we move them into an hourly employee, unless they're a physician, IT person, or attorney, when we move them into an hourly position, they immediately become non-exempt. You then are only required to pay them for the hours they work. How do you determine what that rate is? Many employers will simply take the salary divided by 2,080, leave it at that, and then the employee receives compensation or for the hours worked. I've gotten a lot of questions about, well, does that mean we won't be able to take them back to exempt after businesses resume to full operations? Can I move them now back to exempt? I would say yes, you could. You have to go back to paying them on a salary. Assuming that they meet one of the duty basis tests, you could take them back to an exempt employee at that point, changing them from non-exempt, or changing from non-exempt at that point to exempt. I would not recommend that organizations flip-flop back and forth. So exempt employee, you're getting salary on one week, now the next week we're going to make you hourly, then we're going to make you salaried, then we're going to make you hourly. I would look to do it in a much longer increment. If you want to reduce your costs for salaried employees, a couple ways to do it. You are able to simply reduce the salaried employee's salary. So you can reduce it down to $6.84 per work week. That would still keep them exempt because they're meeting the salary basis test. You just simply reduce their salary that would be something you could do. The other thing you could do for salaried employees, some organizations have been doing, is flip-flopping their salaried exempt employees. One works one work week, one works the next. One works one work week, one works the next. Because you're not required to pay a salaried exempt employee for a work week in which they perform no work. So when you tell your salaried exempt employee from the 1st to the 7th, you're off, don't do any work, that exempt employee does not need to be paid for that work week. Then the employee who's job sharing, for example, they would receive pay, then you could flip the next week and pay every other work week.
So question on job sharing.
Sure.
So, we all have a tendency to, or many of us have a tendency to have our work email on our personal devices. So this person you're job sharing with that has the week off is answering emails during the off week. Does that create an issue?
I think it does create an issue, particularly under the thing that has been a kind of, the thing that was the big thing for about 2 months before all this came up, which is the comps order from the Colorado State Department of Labor, where it addressed what work time would be, as I identify in this slide here, that it may be anything longer than a minute. I'm not really sure that's what they meant to imply or state, but certainly any employee who's answering emails, any employee who's, if you're job sharing, so John, you and I take 1 week, you take the next, I take the next, so on and so forth, and during your off week, you're sending me emails, hey, Michael, this one came in, tell Bob this. Hey, Michael, this one came in, tell Alice that. That could be a problem because now during your off week, you're performing substantive work. You are not off in full for the entire work week. I think that would cause a problem.
I think that's going to be hard to do because usually individuals have particular responsibilities within a business. And if I'm on my on week and the client calls in and it's really your client, I'm very likely to send you an email and say, hey, Michael, what about Joe Smith?
Oh, yeah. I think, this is not an FLSA talk, but the Fair Labor Standards Act law was created in 1939. We didn't really have a lot of iPhone technology in 1939.
Yeah.
So the law was created to take the approach that when we were at work, we were working. When we left work, we just stopped working. And unfortunately, or fortunately, depending on how you want to look at it, sometime in the early 2000s when we got these technology and cell phones, that line blurred. So I think it would be very tough for an organization to say the employee is performing absolutely positively no work during the work week, or only minimal work to be declared off work. So
right.
Something you need to keep track of as an organization.
So Aaron is asking, if an exempt employee is using intermittent leave under the extended 10 weeks FML, is the 2/3 pay for the leave under this leave considered a deduction of pay and therefore not allowed? Should they receive their full salary while on this intermittent leave?
That's a great question, Aaron. I think that what you could do with your exempt employees is the FMLA, as it currently, or as it has read since 1993, does permit you to give your exempt employees intermittent leave under the FMLA, pay them on an hourly basis, or actually it's not pay them on an hourly basis, it's reduce their salary on an hourly basis without losing the exempt status. So if you had an employee who was exempt, they worked 5 hours in a day and then didn't work 3 hours because they were using that leave, either one of the sick leave or what I call the kid leave, you could deduct 3 hours from their paycheck without losing the exemption, because FMLA permits employers to deduct from an exempt employee's salary for FMLA reasons without losing the deduction. One of the things the FMLA addressed way back in 1993. That same right would exist under these new leaves. That's one of the interesting things that's come up under, there's been a debate. You can definitely do intermittent leave under the kid leave, the initial expansion leave. There's been an argument that you can't do intermittent leave under sick leave. I still like the argument better that you can do intermittent leave under the sick leave, but the regulations did not slam dunk that explanation. Questions?
We have lots, but.
And you want to?
Okay, so Sarah asks, I have a client who hired a manager to be salaried, who is set to start March 24th, prior to the COVID pandemic. The start date has been pushed back due to circumstances, but is the client okay to bring the manager on as an hourly employee to train in lieu of starting at salary? They don't have full-time work, but want to take the opportunity to train during the downtime.
Yes, you could definitely transfer that employee to a non-exempt status. The employee may say, well, I'm not willing to take that anymore. Would they then be eligible for unemployment benefits? Obviously, they haven't worked for that organization, so that probably would be a real issue for but organizations do have the right to change their employees to a non-exempt status. One of the questions we often get, but one of the questions, the buzzword that we get frequently nowadays is furlough, which is always one of those buzzwords that causes me a little pause and hesitation, because initially for years, furlough has been unlawful the way it operated. So we're not going to talk about the way it used to operate. We're talking about the distinction now, is that furlough tends to mean an employee who has had their schedule either greatly reduced, substantially reduced, some amount of reduction, or is basically taken down to zero, but that employee is still an employee in the organization. The employee would be eligible for those leaves because they are still employed by the organization. The employee would also be eligible for some amount of unemployment, as it shows up on the screen. An employee may be able to collect partial unemployment if they have their schedule reduced below 32, all the way down to zero. They would be eligible to apply for unemployment. So those furloughed employees, so to speak, who have had their schedule reduced or their schedule completely eliminated, but they're still employed by the organization, they're still receiving health insurance, they're still under the organization's workers' comp coverage or whatever, they are still an employee. Now, this is the distinction from those employees who are laid off. Those employees who are laid off in full, of course, are not currently employed by the organization and would not be eligible for any of the benefits, would not be eligible to take these leaves because they are no longer employed. The other one that gets discussed a lot is employees, and their materials identify this, employees who are laid off with job attached. That is not a furloughed employee. They are no longer, the difference being they are no longer employed by the organization. But they are also not, because unemployment requires employees to go out and look for jobs. An employee who is job attached is not required during the job attached time period to go out and look for a job, but that's not a furloughed employee. A furloughed employee, the way we see it being used is they're still under the organization's umbrella, still employed by the organization. An employee laid off with job attached has been laid off. They are no longer employed. So those are the three terms: full layoff, no job attached status, layoff, job attached status. Both those are no longer employees. And then we've got the furloughs with how many ever hours their schedule has been reduced to, still eligible to accrue leaves perhaps, still eligible to take advantage of the federal leaves or use those federal leaves, still part of the employer's organization.
So question on furlough. So say someone's furloughed for 30 days. Is under the, and I made the comment earlier, furloughs aren't really applied legally.
But that's the old days. Now we're fortunately changing that term to mean something else.
Okay, so say
I'm much happier about, because the old days it was illegal.
Say I'm furloughed for 30 days. I'm still an employee. Is the employer obligated to continue to pay things like health insurance and for me if I'm furloughed?
Yeah, if you're furloughed, If you're a furloughed employee,
And I have health insurance.
right, and you have health insurance, they're still your employee. That both the organization and the employee still need to continue on with their obligations. Particularly for those employers, this is really relevant, who are under the Affordable Care Act, 50 or more employees. Be very careful of simply dropping your employees from health insurance coverage because, for example, they go down to furlough or they become PRN or something like that. The Affordable Care Act doesn't permit you, what?
PRN.
I don't know, actually, just temporary employee. PRN is a term I always see used.
Different from PNG.
Yeah, sure. Different from a lot of things. PRN means just another term I see for temporary employee,
Okay.
casual employee. Those employees, you can't just drop, someone will text me undoubtedly and say, this is what PRN is.
PRN is as needed.
There you go. I don't know how you spell as needed to get PRN, but there you go. PRN employees, we'll see a lot of organizations transferring full-time employees to PRN and saying, well, you no longer get insurance benefits because our PRN employees don't get those. Don't forget, under the Affordable Care Act, there's a calculation that needs to be made before you simply say to an employee, you're no longer under our health insurance. Those under 50 who don't have Affordable Care Act concerns, make sure you're checking with your health insurance policy. But generally, they're saying 30 or 32 hours are required. But generally, that's a calculation more than work week by work week, because you're not dropping them on, dropping them off. It's not just that. So generally, employers and employees are still required under the health insurance to continue.
We have Heather asking about furloughed employees applying for unemployment benefits.
Any employee who is subject to a reduction of wages to the extent, or any reduction of hours, as identifies here in 32 hours, it doesn't matter what we call them, they're eligible for unemployment benefits. One of the things I've been cautioning employers about is providing too much legal advice to employees about eligibility for unemployment benefits. The reason why I say that is unemployment's a little busy right now, and they may make mistakes. I've seen previously, before all this started, a laid-off employee was told by the department, you're not eligible for benefits. Well, that's not true. If you're laid off, you're eligible for benefits. So unemployment they can make mistakes. That's why they have an appeal process. So what I've been telling organizations is, what you want to do is you want to make resources available to your employees for how to apply for unemployment, basically giving them maybe the website, giving them the link, saying, hey, you've been subjected to a reduction of wages, reduction of hours. You may be eligible for benefits. That's something that will be determined by the state. If you want to apply, here's the link you can use. Don't tell your employees, oh, you're definitely eligible, because if something happens and for some reason they're not, employees tend to be very mad at the employer at that point, instead of maybe directing their anger at the Department of Labor, saying, you told me I'd be eligible. Employers don't actually make that call. So what we want to do as employers is make resources available to employees, not make the final determination as to that.
So for all of you whose brains were burning wondering about PRN,
No.
PRN comes from the Latin phrase pro re nata, and it means as needed.
Oh, there you go.
A PRN employee is a part-time employee with no assigned schedule, called into work when needed.
There you go. That's what PRN stands for.
Now we know.
A good, my Latin, I actually took Spanish, so my Latin knowledge is limited.
Now you can fling that out there and know what you're talking about.
Yes, that's the one thing I hold on to, is Latin knowledge.
So Ivan had asked at the beginning, do you mean recordable, is COVID infection from a workplace a recordable incident, and that's recordable for OSHA?
Recordable, that's a good question. I haven't seen OSHA address that. I think the difficulty in OSHA it being an OSHA issue, this frequently comes up more in terms of a workers' compensation issue, is the way, I always joke, I skipped the day they taught medicine in law school, but as I understand the way COVID is spread, it would be very difficult to say with definitive proof that I contracted COVID at work. I contracted COVID here or from this person. You could be contracted from a lot of different people. So I think workers' comp's going to take the approach going forward that it's too nebulous to say that it definitely came from a workplace. I would assume OSHA would do the same thing with their regulations. So I don't look at it as a recordable event.
And Deb had asked if somebody had tested positive for COVID-19, stayed home, recovered, and now they still have someone within their household who is tested positive. When are they eligible to come back to work and not on some kind of quarantine?
That, from a medical perspective, I cannot answer. Once they run out of the leave under the sick leave, they would be uncovered then. Let's say they used all 80 hours to recover from COVID, and now a family member is needing COVID or is needing COVID help. They would not be eligible under the sick leave because they would have used all of it. Now, you as an organization can certainly grant your employees additional leave, but whether or not they're able to come back, I do not know enough. I think the current, at least what I've read, is once you have it, you build up an immunization to it. Knock on wood, that would be good news.
And one more question from Delesa, I believe. Do medical providers have to do anything to exempt themselves?
No, the medical providers are simply exempted by the virtue of being a healthcare provider. One of the questions I frequently get from healthcare providers is, do we have to post the poster? Because that's one of the requirements, is post the poster. And people are concerned, if I post this poster, that means that my employees are going to get confused. I don't think there's the requirement for posting the poster. It would be akin to those with under 50 employees have never been, those with under 50 employees have never been required to have a handbook policy for FMLA. Those with 50 or more employees have to have a handbook policy for FMLA. So equating that right now, I would think if you're exempted, you are not required to post that poster. And Jeremy asked before the talk, if we categorize an employee as full-time, our full-time threshold is 80 hours, are they entitled to the full allotment of 80 hours, even though they may only work, for example, 30 hours? No, Jeremy, they would not be eligible for that 80 hours of pay because if they're not exempt, they only get what they're working. If they're exempt, keep in mind that working 30 hours or working 20 or frankly maybe working 1 would give them that full leave, or I'm sorry, full salary. So those are all the questions I have. So any materials you have questions on, don't hesitate. My contact information is on that front slide. Certainly be willing to help organizations as you're going through. Is there one more question?
No,
okay.
I think we're good. So
thanks so much, everyone. Please, send my just please try to stay healthy. The governor's order is with respect to the isolation has certainly helped Colorado, and I would ask those of you out there to do what you can to comply. And I send my thoughts and prayers to those who are dealing with this, and certainly those medical providers. We all cannot thank you enough. I think just from my own personal standpoint, it's certainly always, I've been watching those videos at 7, 8 o'clock at night that are posted of people cheering the healthcare providers change shift or start a shift. And so to all those healthcare providers listening, I extend my deepest thank you for everything you do for all of us. Thank you.
Yeah, and special thanks. I echo that. I've got my youngest son is a firefighter in Grand Junction, and his girlfriend's a nurse in the NICU, and both of those are frontline people and deserve our respect. Police officers, they deal with people on the street and whatnot, and we still need them out there, and it's a tough deal. So, Michael, thank you so much for your time again today. We have one more webinar scheduled on Tuesday the 14th at 10 a.m. with Chris West and the Dalby team to present about the tax implications of this. So please join us for that. We will, part of the information we send out to everyone today will include that in a way to sign up for that. Timberline Bank, who did a presentation on the SBA loan, piece earlier
On Monday.
on Monday. I was gonna say this week, it's kind of upside down. We'll also be presenting about the PPP loan forgiveness, and this webinar will be scheduled in the next few weeks. And so we will be sending out this recording of this to you this afternoon, and it will also be posted on our blog under autopaychecks.com. So here at Autopaychecks, thank you so much for attending. We are privileged to bring some of our most trusted advisors to you, and it is a pleasure to do so. So thank you so much again for your time, from John and Manon and our team here at Autopaychecks, and Michael and your team, and their support of our community and all of our clients. So thank you.
Thanks so much.
Thank you.